So I am in my final year of PhD and working mostly on 18th and 19th century equity between Queen Mary and the National Archives. As part of this, we end up giving these sorts of presentations on a regular basis. And what I wanted to do was introduce you to two record classes which I thought might be particularly interesting or useful for women's legal landmarks, and to show you the show you the record sets through two specific examples. So the two record sets that I want to use are the probate records and the records of the Court of Chancery. So the probate records at the National Archives are held from the middle of the 14th century up until the middle of the 19th century. The wills that were lodged in the PCC, Court of Canterbury, it's not every will that was ever made. It was outside of London wills which had an estate to the value of £5, or inside London wills which had an estate to the value of £10, or wills where the estate had property in 2 or more dioceses. So the actual wills themselves have been scanned and are available for download from the National Archives website. You do have to pay a fee if you're outside of the National Archives, but if you just go down to Kew for an afternoon, you can download them for free, and Kew is a very nice place. Other categories of record in, other types of record in the probate records have been digitally catalogued in a very, very high level of detail. Now, they're not available for download, but it does mean that the record is very easily searchable, and I'll hopefully show you how we can do that. The only class of record in probate which isn't very highly catalogued online are the intestacy records, and to that extent they remain somewhat inaccessible. Okay. So the example I'm going to use is the will of Elizabeth Booth. Now, we were doing a project a number of months ago on linen drapers, and we just typed in draper into the online catalogue, limiting it to search under probate. And of course you get hundreds and hundreds and hundreds of drapers. But one of the wills that was litigated was this one relating to Elizabeth Booth. And in the will she says, if I get my rotation, I give and bequeath unto the Reverend Samuel Wilson the sum of £20 to be laid by him out in shop goods for my sister, in such time as he should think she is in need or distress. And I do hereby declare that the reason why I give my said sister no more is because she has never been careful to improve upon the advantage she has already enjoyed, and because of that unkind disrespect and most scandalous abusive behaviour I have met with from her. So essentially saying, I could give you more, but I actually don't like you very much, so £20 is all you're getting. So if you search Elizabeth Booth into the probate records, we then find quite a large number of entries relating to a case called Hughes and Wilson. And this is the lawsuit arising out of that clause that I just read out. So we can see 1, 2, 3, 4, 5, 6, 7, 8 entries, all relating to one case. Now, this case wasn't reported, it's not a legal landmark per se, but it's just illustrative of the sort of things that you can find. Now, a case in probate was brought first by bringing what was called an allegation. So if I go back, you'll see. So if we order up the first record, probate team /55/25, so that's the 55th box of probate 18 and the 25th record. So if you call up probate 55, you'll get a box sort of like this, and you undo the string, and lo and behold, you wander through. They're never in numerical order, but number 25 will be in there. And eventually you'll isolate something like this. So this is the allegation, this is the way the claim was brought in probate, and it sets out the main facts and the allegations against the defendant. In order to work out what happens next, you've got to go to another record class called probate 25. These are the answers of the defendants. Now, it's fairly typical at this stage that we sort record by type, rather than by case, because all of the documents came in at different times. The answer might come in January, or the allegation might come in January, but the answer might not come in until June. So if you're a clerk in the court, it's much easier to file all of the allegations together from January, all of the answers together from June, and then it's left to the archivist or the researcher to bring them all together. So we go to probate 25, we turn to the relevant year, we turn to the back, and we'll get an index like this. So if the defendant's name begins with an M, it'll be under M, it'll give you the page number, and then you flip back to the relevant page. So the defendant here was Samuel Wilson, so go to W, we find the folio number, and we'll get the answer. And that sets out the defendant's position in relation to the case. So the allegation in Hughes and Wilson is that Elizabeth Booth wasn't of sound mind when she made the will and couldn't possibly have only intended to leave her sister £20. The executor responds and says, well, seems like a pretty valid will to me, but we'll have to go to court. So you then get evidence that was submitted in the case. So in Prob 20/256, we get a draft will of Elizabeth Booth from some years beforehand, which doesn't include the disinheriting clause relating to the sister. So you can see that there's been some shift in personal relationships between the time the draft will was made and the time that the official will was lodged in the PCC. Similarly, in Prop 31, we get an inventory relating to her business as a draper. And it's too small there, but you can see that the total stock in trade is £3,364, 17 shillings and halfpence. I calculated that as roughly about £250,000 today. So this is a sizable estate, and £20 is quite measly by comparison. So you can start to reconstruct these people's lives in a fairly high level of detail, from how they originally drafted their will to how much money they had at the time of their death. Having gone through this, then, we get the sentence. Now, up until the mid-18th century, the sentences or the judgment of the court are recorded in Prop 11 and are therefore available for download. After that point, unfortunately, the judgments of the court move into a different record class and therefore aren't digitally scanned. Unfortunately, the sentences aren't particularly interesting. It usually will be a blank verdict. Either the will was valid or it wasn't. If there are more difficult legal questions to be litigated, usually these will move into the Court of Chancery, and that's where I want to take you next. A few sort of more things about probate. This is just a general example from the middle of the 18th century. The record is pretty much this detailed throughout most of the sort of early modern into the modern period. If you're looking for wills after 1858, unfortunately you need to go to more other local record offices, but if you're doing research on wills or on probate, the best place to start is the guides on the National Archives website, and they can then direct you to where you need to go if you're looking for a non-PCC will or a will after 1858. Does anyone have any questions just about probate generally before I move on to Chancery? Yeah? No? Okay. So, the Court of Chancery is the area that I work on most. Because it didn't have oral evidence, everything was written, everything was submitted to the court. Now, this meant that justice in Chancery was dilatory, it was expensive, everything that Dickens criticises in Bleak House. But what it does mean is that it's a wonderful treasure trove of records for the researcher now. So the Chancery dealt with, amongst other things, wills, trusts, settlements, inheritance, the administration of estates, but also the contracts of sailors, of expectant heirs, of married women, a whole sort of panoply of social issues. It is sometimes called the Court of the Wealthy because Chancery or equity did become a very expensive jurisdiction, but also because equity often requires some property on which to fasten its jurisdiction. So it sort of requires you to have property in the first place before you would even bother going to this Court of Justice, this Court of Equity. One of the things that we'll see from the example that I give you is that the online catalogue isn't as full or as complete as the probate catalogue. We are working on it, but it requires sometimes a little bit of imagination or a little bit more work sometimes to find all of the documents relating to your case. So, the first example of Elizabeth Booth I got just randomly, just as part of another project. This one is one called Leonard and Sussex, which is reported in the second volume of Vernon's reports. So it's a reported case, but you'll see that the report's quite short. This is typical of 18th, early 19th century reports, is that they may be 1 page, half a page, a paragraph. They often don't give you an awful lot of factual detail about why the case arose. They may not even give you really that much of a judgment. They may just give you a statement and then what the order was in the case. It's at points like that that the archives are so useful for enriching the reports. It's also worthwhile to note that in this period, it's clear that lawyers were continually using not just what was reported, but were constantly going to the record in order to find precedents. You find, I'm sure you can't see this, but at footnote 1 on the second page, it makes reference to Reg Lib 1705B, folio 117, and that's the 18th century way of referring to the record, and I've got a picture of that record at the end, so we'll see how we get there. So lawyers at the time are using these records. They are important for practice. So this case concerns the will of the Countess of Sheppey, who decided that her sons weren't really to be trusted with her vast fortune, and therefore granted them life estates, but nothing more, in her will. And the sons then challenged this. So we go through, again back to Prob 11, we get the will disputed in the case. And in it, she's quite candid. The report merely says that she limited her sons to a life estate, but doesn't actually say why. When we read the record, we see that the reason why was because her son Francis, she said, "In regard that I know my said son Francis is very unknowing in business of this nature," therefore refusing to leave him the entire inheritance, limiting him only to a life estate. Relating to her son Henry, she was rather more straightforward. "And whereas my said son Henry, by his late marriage, which is very distasteful to me, have much drawn my kindness from him, I having formerly given him the bulk of my estate." She then goes on to say, "I'll give you £50 a year for every year that you're married to your current wife, but I'll give you £100 if you marry someone else." The Chancery say that this is a void condition.
Yes.
But it's but none of this is in the report. We need to go to the record in order to enrich our understanding of what's happening in the case. So, as a result of this partial disinheritance, the sons bring a case in Chancery. So, the way cases were initiated in Chancery was to bring a bill of complaint, and it essentially set out the nature of the dispute and the relief desired. So the bill of complaint, this is it in the catalogue description. It's C10, C for Chancery, /500/16. Description in the catalogue gives us the names of the plaintiffs, Francis Leonard and Henry Leonard. You'll notice that the report spells it Leonard and the record spells it Leonard. Just, you've got to be on top of the fact that spelling isn't standardized in this period. It's very common for the names to change around when you do archival history. The defendants are the name of Thomas Leonard, who's the residuary legatee, and Sir Charles Cotterill, who's the executor. Subject, personal estate of Elizabeth Leonard, Dowager Countess of Sheppey, deceased, document type bill only. So this is just a bill, and you'll get a document rather like this. Now these documents are huge. This is over a metre wide and maybe a metre and a half long. You know, these are large documents, or can be. Maybe a metre wide and a metre and a half long. But they have a common form. They tend to repeat quite a lot, so you can get your information out of them quickly without having to read the entire document. But it depends what period you're working in. So again, the sons set out there. They say, you know, this is a void condition. We should get our entire inheritance, not just a life estate. The answer to this case is, you'll see it's a much shorter entry in the catalogue. It says Leonard and Cotterell, date 1685. Now this is problematic. I had to go through an awful lot of documentation relating to this family before I found the right answer. So you'll notice that the defendant's name changes. The defendant's name changes because it's the defendant Cotterell, not Leonard, not Sussex, who is answering. So you've got to bear in mind that short titles can change. Now the date says 1685, which sort of stumped me for a bit until I called up the document. And although it's faded, it clearly reads November 1689, and also makes reference to the fact that Countess Shelley was dead by that stage, and she didn't die until 1686. So the record, the online catalogue takes from contemporary finding aids, so they were made at the time by the clerks of the court, which means that our online catalogue, until we update it by reading the original documents, will only be as accurate as the contemporary finding aids were at the time. These are just the problems of archival research. So we get an answer. It's a slightly shorter document, but again, sort of a metre wide, half a metre long, of the defence of the executor. So once we've got all of the pleadings in, the parties might well submit evidence to the court, such as the draft will that we saw earlier. The case might be remitted out to masters to take an account. Unfortunately, if those documents were made in this, or if those reports were made in this case, they haven't survived, or I haven't been able to find them yet. So we go through the evidence stage, and then eventually we get to the judgment stage. Now, in order to find the judgment for the Chancery, there isn't an easily searchable online catalogue, so you've got to go back to the contemporary finding aids. So these are what are colloquially called the A and B volumes. These are indexes. There are many, many shelves of these, and they range from about 1540 up until the late 19th century. And then we move into the modern High Court of Judicature after the Judicature Acts in 1873 to 1875. So we go to the 1705 volume, which is the year we know that judgment is handed down in the case. The reason they're called the A and B volumes is volume A for 1705 will contain all of the first name plaintiff's surnames that begin with any letter between an A and a K, and B volume will be from L up until Z. So Leonard and Sussex will be in L, it'll be in the B volume. We turn to the B volume, we look up L in, this is Michaelmas term, L's in 1705, and it's not in alphabetical order. These are just the cases as they came in listed. You've got to go through each entry until you find the name of your case. So Leonard and Sussex, it's, as I recall, on the third page of Michaelmas term 1705, and here it is here. So it'll give you a page number, and you then correspond, or the folio number, you then correspond the folio number to the Register of Judgments in 1705, and you'll get the answer, and you'll get the judgment in the case. And the court simply says, well, you can't cut down annuities based on who you're married to. I think the phrase is notwithstanding his then wife, which I always quite liked. But confirms that the two sons are only entitled to a life estate. So Lady Shelley's will is essentially upheld in Chancery. So you can see the amount of detail that we can draw out of the record. You can see the way that we can enrich the reports that regularly we as lawyers only rely upon. So by reading the report with the will and the judgment, the record shows the case in new, detailed light, showing elements of the defendant's or the litigant's personalities. You can see this underlying familial battle that's going on relating to whether a son's particularly good with money or whether a son's life is suitable, things like that. This allows us to reconstruct life and law in Britain in a very, very high level of detail at essentially any time over the last sort of 800 years, well, 700 years of Chancery. Only by enriching the law reports in this way, at least I think, at any kit, in any case, then we really start to reconstruct and bring forth the legal structure of the past, and actually start to make sense of this vast profusion of law reports that we're sort of left with as practicing lawyers. Anyway, I think that's roughly all I wanted to say, so if there are any questions, go ahead.
Can you tell us what happened in Elizabeth Booth's?
Oh, they upheld it as valid, and she was duly disinherited. You know, it's very difficult to overturn wills, so we get large numbers of records coming into probate. Essentially, people chance their arm to try and overturn a will and gain some greater inheritance in intestacy. But by and large, they all fail. It really, really is very difficult to overturn a will, and so it should be.
Are there no other questions?
Could you say a bit more about post-1858? Post-1858?
Oh, well, in Chancery we've got records going all the way up to 1873, and then we move into the Judicature Act. So those haven't been catalogued in a very high level of detail. We still need to go through an awful lot of these sorts of contemporary finding aids. And those records continue up until the early 20th century. Unfortunately, Lord Denning's committee in the mid-60s did destroy an awful lot of our records relating to the 19th century and an awful lot of to the 20th century, and an awful lot of the finding aids relating to the late 19th century. All the bankruptcy records largely destroyed, for example, just because they thought they're too expensive to house and no one will want to look at them. Suddenly, 50 years later, this doesn't seem like such a good idea. So into the 20th century, we lose quite an awful lot of our legal records. But late 19th and the early 20th century were still okay.
Is that why I can't find any records of administration or probate dealing with the deaths of 2 people in 1924?
Very possibly, but if it's to do with intestacy, well, then it'll be problematic to find them. Also depending on where they died. So if their estates are worth a certain amount, they'll come into the probate records at Q. But if their intestacy is below a certain, if their estate is worth a relatively small amount, then it might be administered in one of the local courts. So if they died in, for example, Gloucester, then their records might only be in local record office.
Sorry, and it seems to me that some of the other estates which are intestate are actually really very small, and I would have imagined there were at least a couple of £100 in these. So you think they probably just were destroyed rather than somewhere else?
Well, if they've survived, they're likely to be in local holdings rather than in the centralised holdings. So although it's called the Prerogative Court of Canterbury, it did sit in, I think, near St Paul's. So it's a London-based court, which is why all of the records have remained here. And they moved to the Ministry of Justice, then to the National Archives in Chancery Lane, and then out to Kew. So they've sort of remained in this area. But the local records, they'll still be out in Surrey or Gloucester or wherever. So I'm afraid I can't quite help you with that.
No, that's helpful. It's given me another avenue to explore. Thank you.
A practical question. If we take ourselves down to the National Archives and we're looking for something following the trail, is there on-site support that we might be able to get from an archivist or
Yes, indeed. Indeed. I mean, you can telephone or you can email, and the emails in particular will be sent to specialists. So if you, for example, send a specifically legal query, it'll come down to the legal section of Advice and Records Knowledge, where I'm based, but I don't do the emails. And they can get back to you with more advice as to what you're likely to find and where you might find it in the records. So you can do that sort of preliminary stuff. Then when you come down to the archives, then there'll be people on site who can help you deal with specific inquiries. And by and large, people do usually find what they want.
Sorry, one more practical question. With very early records, and especially legal records, if, like me, you're neither familiar with the handwriting nor often the terminology, would you be able to get help with that, or would you have to pay for that sort of thing?
Well, you can of course pay for transcriptions and things like that. I find that the best way, I don't speak Latin, so I can't go back too far, but an awful lot of the chancery records, for example, are in English. I find that you start in the 19th century and just start reading handwriting or reading wills, it comes to you, okay, fair enough, you have to puzzle over certain words and things like that. It's always good to have a legal dictionary to one side as well, or Mr. Google is also quite useful. I do it all the time for the 17th century. Just sometimes they're just simply things that you haven't come across, just gaps in your education. But I find that the paleographical skills just come with practice. There's no obviously easy way to do it. But if you start in a relatively recent period and then work back, you'll find that the handwriting only changes by small degradations as you go back into the early 19th century, into the 18th century, into the 17th century. And something that you wouldn't have been able to read when you started is actually very, very easy 3 months later. But I'd say a month to 6 weeks of just reading things is the best way to do the paleographical skills. But constant, also going with a friend, getting someone else with. I'm sure you all have friends who love to go to their records offices with, but just getting someone else to look at the word, someone else with a fresh eye can sometimes be so useful for paleography.
Well,
Thanks very much.
thank you very much, David. That was a wonderful start to the day, I think. Entertaining, so illuminating, and even for those of us who aren't working in those early areas, those issues about difference in spelling, being accurate, checking that the date is actually right, and where you kept saying about enriching, it really does enrich it. We're so used to dealing with reported cases, and we don't in general go beyond that or behind that. So that's fantastic. Thank you so much. That's really great. And now, our pleasure in inviting Alison Lindsay from National Records.
Combinations. My name is Alison Lindsay. I'm the head of the legal and historical search rooms in the National Records of Scotland, which used to be called the National Archives of Scotland, which used to be called the Scottish Record Office, and in the 19th century was referred to as Register House. So if you find any of these descriptions as a place where there are records, that'll be us. Okay? Now, we have a website, very high-tech, very 21st century, and we do have access to catalogues and indexes through that. As David was saying earlier, not everything we have is listed in ordinate detail in the catalogue. Ours, too, is a retroconversion job from the sometimes 19th century finding aids. So it does just depend. Not everything is there, and you will find that when you start looking. We have a fairly varied collection. We are the official place of deposit for government and legal records, but we do also have a considerable amount of personal papers deposited. The Act of Union codified or made standard the fact that Scotland's legal, educational, church systems should remain as they were, which is why they're all very different from the English system. I know almost nothing about the English system. My legal knowledge has been derived entirely from Dorothy Yates. So, I may not be able to answer questions if you think it's something like something else, but I will do my best. So we have the catalogue on the website. It does also offer you access to a couple of others. The NRES is the National Register of Archives for Scotland, and its records, which are still held privately, like the National Register of Archives, which has now been incorporated into the National Archives. Researchers quite like that because it's not been picked over quite as thoroughly as material in a public archive, which is much more accessible. And SCAN, the Scottish Archive Network, is material held elsewhere in Scotland. Top level finding aids for about 70 Scottish archives. It also has a contact page. It's got a directory for all Scottish archives, addresses, telephones, emails, links to their websites. So it's a one-stop shop if you're trying to see what you can find about something. If we go back here, We also have the second line, we have research guides, quite a number of research guides, which you can take a look and go through. We also have a book which has gone through quite a number of different editions called Tracing Your Scottish Ancestors, and yes, I know we're not doing ancestral research, but most records ultimately are about people, and it's quite a quick way of finding out what kind of records you can get hold of. We have a paid website, scotlandspeople.gov.uk, which will let you have access to older birth, marriage, death and census records for a small fee. Wills and Testaments is similar to what David was talking about, up to 1925, valuation rolls, which are property records from 1855 to 1935. So if you're working on a person, you'll probably want access to that kind of information. There are indexes also on it to more modern birth, marriage and death records, but they can't be viewed online. You would need to order them, again, for a small fee. I brought this example to let you see what you can get from the census. I mean, I'm sure you're already familiar with the census as a place to find families, ages, where they were born, material like that. Jessie Crystal McMillan, I had a wee look at her on the census. And in the 1881 census, as part of the family, she's Jessie C. McMillan. She's called after her grandmother. Jessie Crystal was her grandmother before she married. So Crystal's a surname, not a forename. In the 1891 census, she's at school in St Leonard's and St Andrews, and she's down as Crystal McMillan. So she's actually chosen her own name, at least I think it's an indicator she's chosen her own name from quite an early age. So that's just a small example of what you can pick up from the census that perhaps isn't directly related to the obvious information it contains. In the National Records of Scotland, from the National Archives, we've got quite a considerable amount of court material. Sheriff courts, which are the individual, the local areas, as it were. High Court is the Supreme Court, the High Court for criminal cases. The Court of Session is the highest court in Scotland for civil cases. We also have barony and regality courts, but they're much, much earlier. They're not likely to affect you. We have an alphanumeric system of references which hopefully bears some relationship to what the records are actually about. So 80 is South Coast Department, Court of Session, Sheriff Court. So you can use these when you're interrogating the catalogue to take you a little bit further forward. About 98% of our catalogues are available online. There's a number of finding aids which were their own physical state, or the way the information is expressed haven't been digitised and haven't been added to the catalogue. So if you do think that something isn't there, do please get in touch. We were talking earlier about Crystal McMillan and the attempt to bring a case to be regarded as a person to be able to vote for the university MPs. Now, one of the maddening features of the older catalogues and indeed the cases is that if it's a group bringing an action, it tends to be somebody's name and others. And I got absolutely nowhere with Crystal McMillan. So I had to look for the names of all the people involved in this action. And I finally found it under Margaret Mayer, Miss Margaret Mayer and others. This again actually isn't in the catalogue, but I have established the reference from one of the large volumes, the handwritten lists of cases that we have. So as I say, if it's not listed, it doesn't mean we don't have it. Just come back to it. If you do want to do a search, this is the catalogue where you can search. They're all much for muchness actually. You can do a title, a subject, a name, but do be aware we don't have keyword search, and we haven't gone through in every reference to Madras we put India in brackets afterwards, and you may have to try and outthink the catalogue. But that's always fun. That's always fun. What I searched for when I was asked to look into this, because I was woefully ignorant, what I did was simply look for admission as a law agent. It's not until I think 1934 that it's admission as a solicitor. So I did admission as a law agent and put it in date order and started going through it. I did a nasty shot in 1915 when I found a Vivian, but I was fairly sure he was a man, and so it turned out. So I did came across Margie St Anderson and subsequently found out that she's all over the internet. But, so there are ways of finding information even if you don't yourself know. You can always try and do something like this. And here's her petition. With the first page. Now, I will be trying to stress throughout this that you shouldn't look at just one item, one record in isolation. If you look round about, you will actually get more. You'll find out more about the context and also different things. This is a classic. You look at this and think, well, yeah, right, okay, nothing wrong with it. It's a petition, that's fine. If you look at another petition, if you look at a male petition from the same period, it's been printed, but she can't use it because it's all he and him and his. So she's got to have it typed out. So that's something invisible that you wouldn't have seen if you hadn't looked at something from the same period. It doesn't really prove anything. I mean, we already know she's the first woman, but it's just one of these tiny, tiny things she's had to deal with. So her application lists her qualifications, what she's done, what she's been working on. It refers to an apprenticeship she undertook and the indenture of apprenticeship in a particular court, recording a particular day. So this is the Glasgow Sheriff Court Register of Deeds, which record the apprenticeship. Again, if you go through the book, the next entry, the next thing to be registered is an apprenticeship by a man at the same firm, Macleay, Murray and Spence, which in Glasgow used to be known, and this is not in any sense pejorative, used to be known as the Lee, Worry and Expense. So that's the report of the court appointed examiners. The court asked examiners to look into this. They were only looking into her qualifications to be a law agent. They weren't looking at the whole legal business. They were simply looking and examining her qualifications. So setting it forth in the petition, it says number 7 of pro, which is process, number 4 of process. These are productions. They're put into the court as evidence of something, but they are essentially private property. The petition is a court record because it's presented to the court. The report of the examiners is a court record because the court has asked them to give it to them, to prepare a report. But something that is private property can be withdrawn at the end. The productions are not part of the process now. The most famous one was the Duke of Divorce of the divorce of the Duke and Duchess of Argyll. And the minute the case was finished, the Duke's lawyers came and withdrew the pictures of the headless man, which had been some of the productions in the case. So it may refer to items, but they're not actually there, and that's why otherwise you'll worry about it. This is the inventory of the process, and it reports the various things, the 5 writs which have been withdrawn. So if we carry on, the report of the examiners, and it refers to the case of Margaret Howie Strang Hall. This is actually quite an interesting one, since it's her petition. She petitioned in 1900 to be admitted as a law agent. Again, it's not in the computer catalogue, I had to go and look for it. She applied to sit the Latin part of the examination of the Society of Law Agents, but the secretary of the examiners declined to enrol her on grounds of her sex. This is her petition to the court, saying, would you please authorise the secretary to enrol her? And it was refused by the court on the grounds that women were not eligible for appointment as law agents. She was only 18 at the time, so that's actually quite a courageous challenge. Her petition makes clear that her father had died when she was 2, and she was under the necessity of earning her own living, and this is why she's doing it. I mean, again, it's interesting because there would have been other ways she could have tried to earn her living. The classic one in that period is a woman teacher. If you're intelligent, you're able to do that. So that's very interesting that that's what she's doing. She does state in her application that Mr. Daniel Anderson, Solicitor Dunoon, has agreed to take her into his office as an apprentice. Now, I haven't tried looking for that. Whether in the end he did or not, and given that she was essentially through his permission, it probably fell through. But again, you could look in the Sheriff Court books for Dunoon and see if you could find a register of the apprenticeship in the way that Margie St Anderson's was recorded. So, this is a report by Lord Ashmore, again, as part of the process. Because she was the first female to make such an application, he is required, well, he's been asked to do a report to the Lord President of the Court of Session. Now, the first point he makes in it is that it's the first application of its kind under the Sex Disqualification Removal Act of 1919. So even if I hadn't been sure at the time that this was the first application, I'm actually helpfully being told this by Lord Ashmore, which is very useful. Now, he again goes through what had happened. The registrar of the Society of Law Agents had refused to accept Magister Anderson's intimation of apprenticeship within the requisite 6 months of its commencement on the 12th of May 1917. It was a stipulation that people who were hoping to become law agents should notify their apprenticeship within 6 months so that you're ready to examine them or look at them again in 2.5 years. Now, this refusal in 1917 had been based on the early decision of the court not to permit Margaret Hall's intimation. Now, remember at this point, in 1917, the 1919 Act had not been passed, so he was simply basing it on previous information. Lord Ashmore looked into this and demolished it fairly swiftly, pointing out that many male applicants had failed to make this intimation within the 6 months and had yet been accepted. While at the time, in 1917, her apprenticeship could not have led to admission as a law agent, because the Act is still 2 years in the future, the apprenticeship of itself is perfectly legal. He's got more to say about the wording of the 1919 legislation, which he deemed more appropriate to England than to Scotland, but which was readily interpretable using Scottish terms. He also refers to the Law Agent Scotland Act of 1873, which prescribes the qualifications, and Magister and Alison did meet those. So, Magister and Alison was successful in her petition, and hers is the name hailed as the first female law agent, now solicitor, in Scotland, and indeed, as again I subsequently found out, in the UK. But the subsequent rate of applications by women to be law agents did not speed up measurably. Her petition was submitted in October 1920 and was ultimately granted at the middle of December 1920. But because it had to be recorded officially, which didn't happen until January, the date of the complete date of the petition is in January, but it was actually December 1920. The second woman, Isabella Bird, petitioned the court in 1921, but her determination that yes, she could, was not given until July 1922. I actually think she's got a more interesting story, but I won't bore everybody with it just now. But again, what I'm saying is that if you look at just one thing in isolation, you're missing out on the context. So, if we just skip forward, that's the final report of the decision. I drew up a timeline just because it's quite handy to have it set out in that particular way, to give you something to work from, so you've got your facts straight. If we leap forward to the end of her life, this is her will. This is Magister Anderson's will, recorded in 1982 when she died. It names various people, including her sister, who's Ellen Davidson Anderson, now Ritchie. They're all fabulous names for searching. You want a good, unusual name. John MacDonald, you might as well kiss it goodbye right now. But this information in the will, by the time I disentangled it, was enough to let me, using the birth, marriage and death records, to draw up a family tree. Now what I also found in the course of it, Madge is the youngest daughter. She's 5 years older than her oldest sister and 2 years younger than Ellen. Ellen herself trained and qualified as a doctor. So already in the family you're getting somebody who's willing to challenge what at that point was still, largely the status quo. As far as I can ascertain, because I don't think I've necessarily managed to find everybody, and it's much harder tracing forwards than backwards. As far as I can ascertain, the only one who had any children was the middle sister Ellen, and she had a daughter Anne, who married an Anderson, so the family name came back to Anderson confusingly. And the last one on the list here, James Anderson, is Magister Anderson's great nephew. And because he recorded his mother's death in 2010, I had an address for him and I wrote to him. And I have managed to get in touch, though I don't have a huge amount of report because that was just last week. But what he did tell me was he was very fond of cats. And she also hated the name Madge and much preferred to be called Easton or Eastie. So that's quite nice. So I will keep going. I've just put this in to give you a reference because I know you'll be sent copies of the PowerPoint later. Scottish legal terms are often different to English ones. There's quite a helpful online guide there if you want to go to it. There's also at the bottom Bell's Dictionary and Digest of the Law of Scotland, which looks a complete nightmare. Whenever I give people in the search room, they blench a bit. And I say, no, just read the first sentence, understand it before you move on to the second, and you can actually work through it, even with quite complicated things. It does make sense. And the middle one is a very useful essay if you're looking at early women lawyers in Scotland or women studying law, which is not the same thing. We discussed that earlier. Studying studying medicine enables you to be a doctor. Studying law doesn't of itself, as Maddie and Alison found it, enable you to be a lawyer. But there's a very interesting article about the first 2 women to study law at Edinburgh in, well, it was 1909, so that's another centenary. But he brings in quite a lot of information about later legal firsts as well. So that's a very good article. Should you wish to come to Scotland and do some studying in the National Archives, you would be welcome. Email address. Do let us know. Do contact us in advance if you're trying to find something, particularly if you're not able to get in the catalogue, because there are various Byzantine tricks we can use in order to try and find it. Visiting in person, as with most places, proof of address, photograph ID, and 2 unflattering passport photographs. No pens, scissors, highlighters, Tipex, split values, that kind of thing. No eating, drinking, smoking, and that doesn't include sweets, and I do make people spit them out, so don't risk it. And it may be possible to photograph material, depending on the collection, so whichever one start. If you're simply wanting copies, again, get in touch and we'll see what we can do for you. And that's it. Thank you for listening. If you have any questions, I'm happy to help.
Questions? Come on.
Conversation killer, that's me.
Would it be possible to have copies of some of your slides?
Yeah. You'll be getting copies of the slides, and all the participants will get them or send them around.
The slides themselves are probably not big enough to see the records, but I did make sure to put all the references in as well, which is why the screens are sort of packed with stuff.
Would those records be available if I came up to Edinburgh to have a look?
They would be, certainly. Not all the material that we hold is in the building. I should maybe stress that. We have 5 buildings with about 80 kilometres of stuff. Stuff is a professional term much used by archivists because it's like in bundles and boxing volumes sometimes. So it may not be in the building, which is why I would recommend checking in advance. But yes, there's no problem with that. If some of them, the ones that I've been using as examples, have been digitised, so you'll be able to see them on our virtual volumes system. Otherwise, it would be the originals, taking a look through them and either making notes or asking for copies.
Thank you very much.
Okay. I've got some business cards if anybody wants them. If you want to get in touch, I'm quite happy to answer questions either here or if you could something you want to ask, but you need to check something first. You know, just email or something. Okay.
Well, thank you, Alison. That was great. What I took from that particularly was how you use quite standard resources in a creative way, like the will, for example, and working out what the family is, and also that you followed it through to the end and you contacted the descendant. And you discovered that thing about the cats, which
I knew you would like that.
and that she wanted, yes, of course, and that she wanted to be called Eastie. She didn't want to be called Madge. That's very interesting. And Crystal Macmillan choosing to call herself by that name. It's people of my generation tend to think that's something that we decided. Second wave feminists often chose a name, and it's lovely to think that.
Well, actually, a tiny addition to the Crystal Macmillan thing is she had 8 brothers. None of whom have the name Crystal in their names, because I've checked every single blessed one. So, and when you live in Scotland, you know where your name comes from. I know where my name comes from. It's from my grandmother. So she would have known that that's the link with her maternal line. And she's chosen it really at a relatively young age.
Yeah, exactly.
So, yeah, that's very interesting.
And also when you talked about the sister of Madge Easton, I thought that was really interesting that she had a sister who became a doctor because, you know, again, it sort of says these are feminists. They don't just happen to do this. They're doing it as a kind of gesture, and I think that's where history's never been fair enough to women. Or it mostly hasn't been fair to women, and there's always suggested this is just, you know, we've had to do it, or it's just happened to happen this way, and in fact it is.
Well, I did think that was really cool what Madge used to Alison, because she went to my school.
So then you can say a bit about that. Yeah. Great. Oh, well, thank you very much.